Good afternoon, everybody. My name is Sharon Hecker, and I'm the incoming chair of ICRA, the International Catalogue Raisonné Association. I want to welcome everyone, also on behalf of our tireless board members, Matthew Stevenson, Alex Morrison, Sarah Davis, and Edith Devaney, to the very first joint ICRA and ALA, which is the Art Lawyers Association spotlight dedicated to legal issues surrounding the Catalogue Raisonné. Today we have about 203 people registered for this Zoom, which suggests to us that we've hit on a very important topic. And I guess one of my first goals as chair has been to better connect the world of art historians and those of us engaged with Catalogue Raisonné type of work with the legal world. I think that creating intersections between our fields and greater dialogue can be mutually beneficial and actually can help us shape new directions in thinking in our respective fields. Today, we have an amazing lineup of speakers who will introduce themselves in greater details in a moment, but I did wish to thank Ala, Martin Wilson, and Amanda Gray for accepting our invitation to join up with them, as well as our speakers, Amanda and Martin, and Steve Schindler, as well as Pierre Valentin, who is our ICRA's founder, all speaking from different jurisdictions and different parts of the art world. So it's a very rich group of people speaking. I also wanted to mention ICRA's upcoming visit to the drawing room for those of you who are in London on June 27th, as well as another ICRA event coming up in the fall. Again, it will be attached to legal issues, and our 6th annual conference, whose theme we will be announcing very soon. These events all help to support the high quality of and the content that ICRA is now well known for. Our past conferences are now all available on YouTube on our ICRA website. Last year's conference was dedicated to the works on paper and was held at the Royal Academy. And we also had a wonderful private visit recently to the Louise Bourgeois Easton Foundation for our New York members. Please do consider becoming a member of ICRA. We are a nonprofit membership-based association that brings together people involved in Catalogue Raisonné work and people who are making use of this tool. We really depend on membership for our support, and the next spotlight will be free for our members, and the annual conference will give preference to our members for registration. You can contact the wonderful Emily Gasparo, who has been helping in the back scenes, behind the scenes of this event, and she is always there to answer questions. Today's moderator is going to be our board member, Sarah Davis. Sarah is a media industry general counsel and non-executive director. She's been involved for many years at GMG, who are the owners of The Guardian and The Observer. So she has a long legal experience with publishing sensitive material, and these are questions we often face with Catalogue Raisonnés. Sarah is also involved with arts and culture organizations and is vice chair of UNICEF UK. Just a few last housekeeping notes before I turn it over to Sarah. We've gathered all of your questions that you have sent in advance, and we will try to answer as many as possible during the session. You will all be muted, but you can write things in the chat. We can't promise to get to everything in the chat, but we will do our very best. And also to let you know that this event is being recorded and will be made available online through our ICRA YouTube channel after the event. I don't know if before Sarah begins, if Ala would like to say 2 words about who you are and what you do.
Hi, everybody. It's lovely. First of all, thank you so much, Sharon, for the lovely introduction. And I think this is just brilliant that we're having a collaboration like this. There are so many familiar names here and friends already popping up, and I can see a huge crossover already between the two organizations. So we've got a lot to get through, so I'm not going to spend too long, except to say that Amanda and I are really grateful to the suggestion, and we hope this will be the first of many such collaborations. And that's really all I have to say at the moment.
Wonderful. Have a look at the ALA website because it's a wonderful new organization. Okay, over to you, Sarah.
Well, thank you, Sharon and Martin, and thank you, all of you. Let's just get straight into it because we've got a really dense program of content, really. And I'll come to each of the speakers, our panelists, and ask them to introduce themselves and just a little line about what they do before we get into the questions. So Amanda, because you're first on my screen, can I ask you to just introduce yourself?
Thank you. Thanks very much, Sarah, and thanks very much for this opportunity. Great to see you all. My name is Amanda Gray. I'm an art lawyer at Michigan. I've been here now for about 17 years. I am one of the co-leads of the art law practice group. I have a team of 9. I also am recently chair of the board of trustees at the Photographers Gallery, taking over from one of your members, Matthew Stevenson, who joins us today. I also co-chair with Martin Wilson, ALA, and it's lovely to be with you today. Thank you.
Sarah, you're muted.
Sorry, thank you, Martin.
Hi again, everyone. So I guess I'm pigeonholed as an auction house lawyer, in-housing auction house lawyer. I started my career at Christie's in the art world 26 years ago, and 6 years ago I moved to Phillips, where I'm also the head of legal. I'm the author of the art law and the business of art. And as Amanda said, we co-founded the Art Lawyers Association last year.
Thank you, much needed. Stephen, could I ask you to introduce yourself, please?
Sure. Good afternoon, everyone. Thanks for having me. My name is Steve Schindler. I'm a founding partner of the litigation and art law boutique called Schindler, Cohen & Hockman. We're located in New York City. I've been fortunate to practice in the art space now for about 20 years, both on the litigation and on the transactional side, representing a broad group of players in the art world. I also co-host the monthly podcast called the Art Law Podcast with my colleague, Katie Wilson-Milne, and we enjoy doing that very much. And I think that's all.
Thank you. I love the Art Law Podcast. Pierre, you probably need no introduction, but can I ask you to introduce yourself too? Yeah, please.
Thank you, Sarah. Well, I'm an art lawyer. I've been an art lawyer all my life. I was with Constantine Cannon until last year. I'm now with Field Fisher. And yeah, ICRA was kind of a brainwave that happened one day. And probably now 8 years ago, it took a couple of years to actually launch it, and I'm now delighted that Sarah, Sharon, and the rest of the board are driving it forth.
Wonderful. Thank you all. Thank you very much. So let's get straight into the questions. And Amanda, if I can start with you, because I think you're sort of perfect to open up the discussion in terms of sort of broad. I suppose the first question was from one of our members, which is, what is the role of the Catalogue Raisonné and what makes a good catalogue from a legal perspective?
It's a really interesting point, and because you can see, having considered it, the Catalogue Raisonné is multifaceted in its purpose, which we'll come on to. At the very top, it is a comprehensive record of an artist's work, the very broadest on the top. And either would focus on the whole of the artist's oeuvre, or maybe, or let's say their works on paper, or their works in another medium, or on a particular time, so a period of time, a period of history from when they are working. They take a lot of time to produce. They're often very costly, and it's at its very best. They are great critical tools that are well researched, which is where ICRA, I see the importance of ICRA as well in that conversation. But they are very best. They're well researched. They will contain a minimum of content. You'd expect to see photographs of the work, title, dates, dimensions, etc., the provenance, the exhibition history, references to relevant literature, essays, introductory essays at a minimum, bibliography, so sources, primary and secondary sources of work. But they are scholarly documents. But they are, interestingly, they are at that juncture and it's an intersection between the world I more frequently operate in, the commercial, that's the transactional side, or you're looking at the litigation side, the dispute side as well, they are this intersection, there's a meeting, they're a bridge, because they are a great resource for art historians, for those that want to know more about the history of a particular artist or works. They will set out the creation of works and put it in an ordered way in terms of the chronology of the artist's works. So they will also reveal something about the evolution of the artist's development. They've got lots of perspective. From my side, they will also be points of reference for potentially used in terms of transactions where people are looking to see, was a work actually in existence? Can a work actually be attributed to a particular? Sorry, there's something in an issue with my sound. I will check my sound after I finish this question. To see in terms of placement of an artwork, whether it's correct for its time, whether it's collecting attributed, as I said, but they also can be used within litigation as well. So they're multifaceted, but they touch upon both the commercial and the academic fields. I might also add, I also see them as living documents, so I don't see them as static documents. They are something that can be developed, they should be built upon as more documentation, more information comes to light and becomes more available. They are not documents that should be, well, they are something that should be developed and built upon, hence various additions, revisions, etc., etc.
Thank you, Amanda. Thank you. Whilst I let you check your sound, shall I just, I'll go over to Martin, actually. So I'll just jump to Martin and we'll come back to that. But Martin, I think, if I may, from your auction house perspective, which is another sort of perspective in the whole ecosystem, I suppose the sort of one of the questions that we're really interested in, our members are interested in, is the fact that a work is in the catalogue or not a determining factor in deciding whether or not to offer a work for sale?
Yeah, I mean, very much so. I think as Amanda was saying, I mean, we operate in this sort of interesting world where we talk about the I, and we talk about we talk about sort of general ideas of recognizing artists through the eye, and that they're not terribly scientific methods. And quite often when we get to court, for instance, it's very difficult for courts to sort of understand this world in which we operate, where there is a sort of lack of certainty. So in terms of determining attribution, the idea of a catalogue which forensically goes through as much as possible of the oeuvre of the artist and records it is extremely attractive. Because it brings a sort of level of formality and certainty to the exercise. So it's important from that perspective in terms of understanding attribution. But as far as an auction house is concerned, what we have to remember is that attribution is a question of opinion. As we all know, it's not, to the outside world, people are sometimes surprised at that because they think that attribution is a question of fact. It's not necessarily, it's a question of opinion. And within auction houses, you generally have people who are, as it were, generalists in terms of they understand a category of art, and they may have specializations within that, and some of them indeed can be very specialized. But in general, their objective is to make sure that their opinions on attribution are in line with the state of scholarship. And that leads us directly to the Catalogue Raisonné. So you can gain some comfort, some legal comfort, and also some commercial comfort from the fact that a scholar who has researched the oeuvre of the artist has recorded this object. So the short answer to your question is, yes, it's absolutely critical in the work of auction houses. And perhaps we could discuss this later, but, it's very difficult to envisage situations where something has either not been accepted for a catalogue raisonné or is not included for the auction house to sort of decide for itself, although it's quite entitled to do so, that it disagrees with the state of scholarship.
Thank you, Martin. Amanda, should we try your sound again? Because I'd like to come back to you then with a sort of question that somewhat follows from that, is what you've seen, and we're thinking about, I should have said, from a UK law perspective, where there are discrepancies, for example, in the market between the Catalogue Raisonné or the heirs or the foundations or owners of the artist's IP. And how does that sort of dynamic play out where there is a discrepancy in the UK context?
But first of all, can you hear me? Is that better? Good.
Yeah.
Right. So sorry about the earphones. You'll just have to bear with the earphones. So discrepancies are really interesting because in terms of the Catalogue Raisonné, it's an authored document, albeit it will rely on facts, but you have to bear in mind that in the context is an authored document. And you will have issues that can arise where if you have discrepancies, for example, if there's more than one Catalogue Raisonné in existence, there are competing authors that are out there that are claiming to be the voice, the authority on a particular artist or on a particular body of artworks in respect to that artist. Now that can create uncertainty in the market, and it links in with what Martin was saying in terms of having reference to a Catalogue Raisonné, say in a catalogue description, etc., in an auction house. If you've got uncertainty between whether a work is in or whether a work is out of a Catalogue Raisonné, i.e. whether it's potentially right or not deemed to be by that or by the artist, that creates a huge problem for that particular piece and for the owner, both in terms of value, as also in terms of marketability. Can it be sold at all as a work by that particular artist? And though the Catalogue Raisonné isn't itself a certificate of authenticity, it can be viewed as such, as being, yes, this work, we have accepted this work into the canon of this particular artist, or we have not accepted that work. It's been excluded, and it will create problems both for the reputation around that particular artwork, and that can have, we have seen it have a knock-on effect in terms of the reputation of the individual who is the consigner about their judgment. And this spreads out in terms of, well, they've made a bad call, in particular this acquisition, or they've been duped, etc. So it can spiral out in terms of that way. In terms of discrepancies as well, you have fluctuations of prices in the market, so it can feed into that. And if you have discrepancies between different Catalogue Raisonné as well, so there's more than one, these can often be a result of different interested stakeholders with their own disputes. So you see potentially this is a part of a wider context. The Catalogue Raisonné itself is part of a litigation. It is a subject to a dispute. It has arisen from that. And you will have different price points in terms of works, and also uncertainty about whether a work is right or not. Say you have one party that's authenticating willy-nilly, and they're just authenticating, then there's another party that says disagreeing with that. That creates about uncertainty about what is right and what is not by that particular artist. So that's very interesting. It also, if you have more than one discrepancies between different Catalogue Raisonné, it also creates a quite attractive scenario for those who may be who are fraudsters, who are creating fake works, who can step in and utilize and step into that void and say, well, there is uncertainty in the market. Oh, look, we've discovered this, we've come across this body of unfound works by this particular artist posthumously. And if there is uncertainty or there is dispute going on between various parties, that's quite attractive to them and they can slot in. Whereas if there's something more comprehensive, there's only one definitive or deemed to be definitive Catalogue Raisonné, there's less room for maneuver or opportunity within that. So it's a fascinating area, particularly when you have these vying or competing areas of who is the right person to attribute a work, who is the author, what is their role, do they have a vested interest in any particular catalogue raisonné. So there are various things around that, but they do impact on the market.
Yeah, thank you. And you can just see how in that space, that sort of being able to exploit the discrepancy is a risk there. But sort of building on from that, it is therefore possible for a catalogue raisonné to be objective.
Well, I would say not. Obviously, because you have an author, they are authored. You will have obviously reference, and at the very top, catalogue raisonnés are fantastic foundations and platforms for greater research. You think of ones that have reignited artistic careers, but they are authored because they are driven by, they're written by people. They will have their own way of looking at things, perspective, and the good ones will recognize that, and they will acknowledge those points where they say, this is my opinion X, or this is the extent of our research, but they will be transparent in that framework. And when you are faced with a document that is stated to be objective, then I think questions need to be raised, because they are all generated by, whether it's a committee, whether it's by an academic, they are coming from these different perspectives. You only have to look at there's one coming out soon from David Hockney, but it involves the artist, it involves his assistants, it involves a number of other people. So they're all coming from different angles. So they can never state to be wholly objective, because they come from humans, from all these different experts.
Thank you. Thank you. So sort of leading from that again, Martin, to you, I suppose a question that's been of extreme interest to many of our members as authors are authors of catalogues liable under UK law for negligence?
So this is a great question, and before I answer it, I'm going to have to give credit to Aaron Taylor, who some of you may know, who's a barrister here in London, who it turns out has been studying this and sent me a few pointers just before. So full credit to him, and apologies for taking his work here and repeating it. But so I think it's really important here to because it's a public policy issue, because what we're trying to do is encourage people to express honest and clear opinions without fear of being sued. But at the same time, so that's the sort of public policy side, but at the same time, we're trying to make people accountable for what they say, because there's a lot that's riding on this. And if you say something, if you take a position on a painting, it's going to have an effect on that painting, and probably a financial effect on the person who owns it. So with power comes responsibility. So it's a really difficult sort of balance to strike, because if you underprotect scholars, you're going to get a situation where nobody really wants to be a scholar at all. And we've seen that in the US with foundations actually backing away from authenticating work. But on the other hand, if you overprotect scholars, you make them omnipotent effectively. And so they're able really to give views which, in some situations, there might be conflicts of interest, or they might give bad faith, or they may just not be properly researched. And so what you want to do is get that balance right. So just looking at the law and how we've arrived there, I have to say at the outset, I'm not sure that we're quite there yet, but so that's kind of the spoiler alert for all of this. But just breaking it down, the place to start really is contract, because that's kind of the easiest, but actually sort of slightly the least relevant in this situation. If you've got a contract with a scholar, and they are to give you advice, that under you will be able to look at the terms of the contract and determine whether their advice has breached the contract, for instance, for having effectively been negligently given. There might be a clause in the contract that says you'll use your that you will give sort of careful advice, and that it will be sort of, and you'll make reasonable endeavors to make sure that it's correct. But the reality is that the most contracts in any event have exclusion clauses, so that probably won't bite. But I think what most people are interested in is this idea of having a duty to the wider public. So what we would call here, in most situations, a duty, a tortious duty, effectively. Not to cause damage to the wider public. And in the UK, at least, there was an early famous case which involved, which I won't go into, but which involved a Scottish lady drinking some lemonade where she found a slug in the bottom of it. And the question was, did the manufacturer owe a sort of wider duty to the general public not to cause them sort of damage? And in that case, it was determined that yes, there could be such a duty where it was foreseeable. So that's the principle. So on the basis of that, you might think, well, whatever you write, if you cause somebody damage as a Catalogue Raisonné author, you might be exposed. But since then, the law in the UK has been refined, and the courts now take the view that that only really applies where it is just to do so, where it's right to do so, which is pretty broad. But I think, and I think Aaron also shares this view, that this is just the sort of situation, the sort of public policy situation, where the courts are not going to say, whatever you write, if it causes anyone a loss, you're responsible. So I think that although that really in that wider sense, that probably it's difficult to say that you've got a duty of care as a Catalogue Raisonné author to the world at large. But there are also other elements to talk where you have to show that you breached that duty. So then the question is, well, did you, in expressing that view, did you fall below the standard that could be reasonably expected of a Catalogue Raisonné author? And again, that is a question of fact, but it's quite difficult, again, I think, to determine exactly what standard would be expected. And finally, obviously, you'd have the person claiming would have to be able to demonstrate a loss. So I would say, in summary, it's quite unlikely that anyone would be able to establish under UK law a duty in a sort of liability for Catalogue Raisonné owners authors in tort. The only remaining ones really are sort of malicious falsehood, where you effectively have to demonstrate that the Catalogue Raisonné owner had it in for you, or for the artwork, and deliberately went out to cause you loss, or did so in a way that was reckless. Again, that's a very high evidential bar to get to, because you've got to get into their head and demonstrate that they meant to cause you harm. So that's another option, but really not one that's likely to be successful. And then finally, there's the sort of criminal angle, and obviously in cases of dishonesty, you might be able to bring a claim against a Catalogue Raisonné author for fraud or bribery. But the reality is, if you're a Catalogue Raisonné owner, I would say you can rest pretty easy that you are not likely to get sued, provided you're careful in what you do, and obviously that you're not that you don't act illegally or with malice against somebody. So that's a long answer to a simple question.
Yeah, but it just shows that it actually isn't a simple question. And thank you for that, and thank you to Aaron as well. So just sort of to press that a little bit, because you're right, it's probably very hard for a claimant, certainly in the UK, to make out that there was a duty owed to them, that there was sort of negligence under UK law. But you do talk about there being a sort of public policy sort of view almost that the courts take as well. And as you say, with great power comes great responsibility. So how does the law ensure that the author of the catalogue exercises that kind of power and responsibility and integrity, really? What are the sort of, looking at it from the other end, what keeps the author true in a way?
Well, I think it's very difficult, because you would think in a situation like this, where so much is riding on one person's opinion, that there might actually be laws that prescribe exactly what the standards are and what one should aspire to as a catalogue raisonné owner. But there aren't. There is no law in the UK which says, you know, this is how you should go about your work. And so really, I think, you know, the answer to your question is really that provided that there's no malice in what they're doing and that they're simply expressing a view, the law is not really going to hold them accountable, and if they do a reasonable job. And what we have to remember is, in a way, that might sound surprising, but there's a sort of strange reversal that happens, because initially, in order to be recognized as the authority on an artist, you have to effectively demonstrate to the art market that your opinion is worth something. But once you've done that, there's a kind of inversion, because at that point the art market becomes beholden to you. And you have the ability to determine whether something flies or not. And so it's an interesting power balance. And so, as I said at the beginning, I don't really think that we've necessarily got that balance right. But at the moment, you'll be relieved as catalogue, if you are a catalogue raisonné author, that you can sleep pretty easy, I think, and without the fear of being sued.
Thank you, Martin. And now, by way of contrast, Steve, can we speak about the US perspective and really the potential claims that have been brought by dissatisfied owners of works against either a counterparty in a transaction or against authors of catalogue raisonnés?
Sure. So it's interesting, because I think, and Martin made reference to this, there was a point in time, particularly in 2010, with the settlement of the famous lawsuit by Joe Simon Whalen against the Warhol Foundation. That litigation, which brought claims against the foundation for not authenticating a work in particular, brought a whole range of claims, from antitrust to product disparagement, negligence, tort, everything. And ultimately, the Warhol Foundation was successful, again, because of the recognition, at least in our system, that these catalogs are opinions. And they're really not more than that. But famously, the Warhol Foundation went on record as having said it spent $7 million to defend the claim. And we didn't represent them, I'm sorry to say, but I know who did, and it was expensive. And so that sort of trigger here, because we don't have, as you do in the UK and most other Western countries, we don't normally have cost shifting, legal cost shifting, that everyone pays their own legal fees here most of the time. And so, of course, the good news was it's very hard to prevail against a catalog author or institution on the merits, but the bad news is it could put you out of business because you spent more money than you had on legal fees. And that prompted organizations like the Art Law Committee of the City Bar and others to try to put forward legislation in the New York State legislature to protect catalog raisonné authors. And mostly that protection was legal fee cost shifting. For a variety of political reasons, even though we tried to do that for a number of years, our trial lawyers here don't like cost shifting, so that legislation never came to pass. But here's the good news for catalog authors. We had a case decided fairly recently, brought by the Mayor Gallery against the Agnes Martin Catalogue Raisonné Company, because of dissatisfaction that works that were submitted were not included, and they felt that the explanations that were given were cursory, which is in fact what the examination agreement that the submitters that the gallery signed said. So ultimately, the court in New York decided, the appeals court decided in favor of the Catalogue Raisonné, the Agnes Martin Catalogue Raisonné group, and also because the examination agreement provided very clearly for attorney's fees in the event that somebody brought an unsuccessful claim, the court awarded all of the attorney's fees in favor of the Catalogue Raisonné. And so, to me, even in the absence of legislation, the moral of the story here is make sure, if you are a publisher of a catalog, that you have a great examination or submission agreement, and make sure that it, says what you are and aren't obligated to do, and that that you get to recover legal fees in the event that you're sued. And that, to me, takes care of it pretty well.
Yeah. Thank you. Yeah, it's interesting because it is very different, certainly in the UK and most of Europe, where costs are a consideration. It actually just means that there's more thought actually before claims are brought in some cases, and so you're not really necessarily just arguing around the cost, which can skew the issues completely. So are there any special procedures in the US that are sort of trying to resolve such claims?
No. We, unlike France, for example, that has a procedure for trying to get a work included, we don't. And it turns out that the courts here and judges are really at a loss in trying to deal with these types of cases. And I think that's because of what we've heard is because of the centrality of the catalog in the marketplace.
Yeah.
It's very often the case that it doesn't really matter what a judge decides. I mean, unlike many kinds of disputes in the US, judges decide, medical malpractice. They decide whether something infringes on a patent. And then, their decisions carry weight because they can be easily enforced. What we see here, and judges recognize this, is that it doesn't really matter what a judge decides about the authenticity of a work and whether it should or shouldn't be included in a catalog, because the marketplace will disregard some judge's view of a work and always look to the catalog. And we've had a couple of situations or a number of situations where frustrated owners and collectors have brought lawsuits against Catalogue Raisonnés in order to try to, not just for damages, but to compel them either to include a work or to declare a work's authenticity. And we saw that in a case brought against the Calder Foundation by the Thomes. Involving seeking a declaration that a theater set that was created by Calder before he died was authentic, and the foundation basically wouldn't include it, and a lawsuit was brought in order to get them to include it. But the court declined to do it. They said, we have no authority to mandate that a private organization include a work in its catalog. It's their opinion, it's their point of view. We don't have any authority to do it. And also declined also to declare that the work is authentic. And judges do make declarations here. We have a procedure called declaratory judgment, where you can ask a court to make a declaration with respect to competing rights. But what the courts acknowledge here is that what they're really being asked to do is to give an expert opinion.
Yeah.
Right. And so they decline to do it because, again, that is the province of the catalog. And because the market follows the catalog, judges are really reluctant to jump in. And so we've seen judges not wanting to interfere with this kind of relationship.
Thank you. And just briefly before we come to the sort of Pierre, who can talk about the more broader European perspective, and I saw we've had some questions on that. rather like the comments by Martin, are there protections that authors of catalogues can take to protect themselves from claims against authors in the US?
Yeah, I mean, I guess what I would say is that anyone who publishes Catalogue Raisonné in the United States should have a very good submission agreement. That is the best protection that authors can have. You have a contract. It says very clearly that you're only required to do X, Y, and Z, and you're not required to give explanations, etc. And then most importantly, in the event of a lawsuit, that the party that brings the lawsuit is going to bear your attorney's fees. And so for me, that is the sort of be all and end all of protection. And I think it's good protection here in the United States, because again, we've rarely seen any situations where a court is going to impose liability on the author of a catalog for an opinion that they expressed. The real risk here is just the incredible cost that litigation can have. And so if you protect yourself particularly against that, then that's the best protection that you can have.
Yeah, both sides have such an interest on it that these aren't cases that, you know, that lend themselves to kind of early settlement in most cases. Pierre, so sort of Stephen's just explained to us that in the US there isn't this sort of declaratory remedy, but in Europe, can a judge compel an author of a Catalogue Raisonné to include a work in the catalogue? Mute, you're muted, sorry. There we are. No, sorry. Yeah, that's great, sorry. Yeah.
Okay. Before I answer that question, I find it really interesting that we're focusing so much on the protection of authors of Catalogue Raisonnés. And don't get me wrong, of course, I'm in favor of that. But, you know, I think it also is important to look at the collector's perspective. You know, I spent $5 million or $10 million or pounds on a Modigliani, and suddenly this guy comes along and says, I'm going to write the Catalogue Raisonné, and I'm not going to include your Modigliani in my catalogue. The result is my Modigliani is worthless, and I've lost $10 million or pounds. A lot of collectors are completely bewildered that this can happen, or even worse, the author of a Catalogue Raisonné dies, and someone else takes over and has a different perspective. And suddenly, what was a genuine autograph work by an artist becomes not a genuine work by the same artist. And again, for someone who is not deeply embedded in the art world, it's completely bewildering.
Yes.
But I'm not answering your question. Now, on the point of whether one can compel the author of a Catalogue Raisonné to include a work in the catalogue, in France, and I think it's true in other countries of a Napoleonic tradition, they thought they'd cracked it. And really, I think it's down to the way in which civil procedure works in those countries. In the UK and in the US, experts are appointed by the parties. And whilst there is an expectation that they will be impartial, they tend to side with the party who's appointed them. In France, for example, you have what's called court-appointed experts. There are something between 8,000 and 10,000 experts who are registered and qualified to advise judges. And the judge will typically follow the expert. So in a situation where I am the owner, I am very unhappy because the author of the Catalogue Raisonné has refused to include my painting in the catalogue, and I sue. The first thing the court will say is ask their expert for his or her opinion. And if the expert says it's authentic, there is a line of cases where the judge will say, well, if my expert says it's authentic, it has to go in the catalogue. And you have those decisions ordering authors of Catalogue Raisonné. The Wildenstein Institute in Paris has been a receiving end of those lawsuits, ordering the author to include the work in the catalogue. Now, all that changed in 2014 or 2015 when the French Heirs Court basically took a different view. They said, well, this is the story of a painting called The White House by a not very well-known artist, or at least not known by me, called Jean Metzinger. The expert on Metzinger was a woman called Nikiel, and she basically refused bluntly to include the White House in her catalogue. And the Court of Appeal in that case went as far as not only ordering her, but fining her. So she had to pay a fine, a daily fine, for every day that she refused to include the work in her catalogue. She was a force of nature. She went all the way to the Supreme Court, and the Supreme Court said, no, no, not at all. This doesn't work. They relied on the freedom of expression in the Convention of Human Rights to say she's entitled to her opinion, and you can't force her to include a work in her book if she thinks it's a fake. So that was a complete change of approach. And I would say now in France, we are probably more or less in the same, or the approach is the same as it is, as we now know, in the UK and in the US.
Thank you. That's really interesting, isn't it? And it kind of goes back to if it's an opinion and it's an authored work, the kind of being compelled doesn't really sit with that, actually, just from a first principles point of view. Are there legal cases in Europe where authors deny their work because of damage to them, or where the work has been highly restored or poorly restored? And where does that leave the author of the catalogue?
Well, that's a big question, I think, and I'm not sure I know the answer. I don't think the law has anything to say about that. I think it's a question of judgment by the author of the catalogue. I think it will depend on the condition of the work, the level of damage. I mean, I can tell you that I've had cases where the artist was alive. I'm thinking of a particular case. An Italian artist was an installation, and there was a transformer, there was a freezing unit. After 20 years, they broke, they were replaced. And when the artist looked at an image of the installation with the new transformer and the new freezing unit, he said, well, this is no longer my work, and therefore I'm not going to agree that it's by me. Now, in a case like this, would you include the work in the Catalogue Raisonné, or would you not? It's very much a question of judgment, and I think there are reasons to include it and reasons not to include it. I think this is very much a gray area. Sharon may have a view. I'd be interested to hear her point of view. I don't think this is a legal question. This is more a question of judgment and approach.
Shall I move on to questions from some other questions from our audience? So I will just try and cover as much, but I'm just conscious of time. We've got 10 minutes, so I'll try and get through as much as possible. Maybe sort of the first question, I'll just take them in order, is a limited liability question generally recommended for a Catalogue Raisonné project? So to sort of minimize risk, I suppose, from a legal point of view, and just thinking about it, actually, Stephen, maybe in the US jurisdiction. Do you have a view on that?
Yes, absolutely. I mean, I think if you're going to have a Catalogue Raisonné here, you normally it would be set up as a limited liability company. That's, in fact, in the Agnes Martin case that I talked about, that catalog is set up as a limited liability company in order to, protect individuals. Sometimes, though, catalogs are published, as you know, by foundations, which is, but also it's also a legal entity. Rarely would it be published, by individuals, and obviously you can't. What we always say here is you can't protect against being sued because, and usually what we do see, we saw it in the Agnes Martin case. Plaintiffs do sue individuals, even if you have a limited liability company, because they allege acts relating to those individuals. In that particular case, the individuals were dismissed pretty early on. So yes, I think it is protection from liability, but not protection from the possibility of being sued.
Thank you. And presumably for our colleagues in the UK and Europe would have the same view.
Yeah, absolutely. I mean, it may well be a very poor claim, but people are mischievous, they bring claims, they're a disgruntled collector, etc., and they will still push ahead, and it'll be a costly and expensive. But again, shared views with Steve in terms of limited liability company, in terms of that kind of protection.
Yeah, lovely. Thank you very much. Pierre, a question really that's come in is the moral right even applicable outside of France? And what exactly can the holder of moral rights enforce when it comes to the works in the catalogue, I presume?
Yeah, I mean, moral rights apply in many countries around the world. They're particularly strong in France because the French claim to have invented them. They apply in the UK, certainly, I think to a lesser degree in the US. I mean, the interaction between moral rights and the authority of authors of Catalogue Raisonné is quite a complex one. I don't think we have really have time to go there. It is true that quite often the holder of the moral rights is also the authenticator or the author of the Catalogue Raisonné. And I think that, certainly from a perception point of view, if you are the holder of the moral rights, that gives you a sort of aura of, respectability. It feels perhaps, from the point of view of the collector, your decision feels less arbitrary than if you are, just an expert, as it were. But having the moral rights in itself doesn't, as a matter of law, doesn't give you necessarily the authority to make decisions on authenticity. In fact, in France, for example, there have been cases where the courts have said the fact that you have moral rights doesn't authorize it. Your moral rights authorize you as the holder to say this is by me, or this is by my father, my mother, but it doesn't authorize you to comment or judge on the works of other people.
Thank you. Yes, Martin, just this may be our last question, but it's a question from Giuseppe in our audience, which is about refusals to include a work in a catalogue requested by a collector, and would the author need to have their refusal sort of adequately motivated? I suppose, sort of what are your grounds for refusing, and do you have to be able to stand behind them, I guess, is my inelegant way of translating Giuseppe's question.
It's interesting, isn't it? Because I think it comes back to what Steve was saying earlier, that really the way that the courts generally seem to be viewing this is that the Catalogue Raisonné author is a kind of scholarly equivalent of an influencer, really, that just takes that is able to take a view, and provided there's no malice in that view, it's just freedom of expression. And so you wouldn't say to an influencer, you have to justify why you like that particular handbag or whatever. And I'm simplifying this in a way that obviously doesn't apply in the art market, but it sort of illustrates the point that is how the courts see it. So good practice, of course, is that you justify your decisions, because it demonstrates that you are not, as a Catalogue Raisonné author, sort of negligent and sloppy in your work, and I think most would certainly do that. But is there an obligation to do that? No. And you know, just as in the influencer kind of parallel, you're entitled, I think, as a Catalogue Raisonné owner to say, just as the guy who says, I've got an eye, and I don't believe this to be by the artist, that you can sort of take the same view. And then of course there's the other aspect, which is if you give a view and refuse to give any kind of motivation, it brings into question what your motivation actually
Yes.
might be.
Yeah.
And there's obviously that leaves you exposed. So the short answer, it's good practice to do it. Legally, maybe not necessary.
Yeah. Thank you very much, Sharon. I'm going to stop there and thank our panel, because we covered a lot, and I'm sorry there was probably no way we were going to get through all the questions, but I hope it was a sort of, you know, an interesting and substantive conversation. Thank you everyone for sharing your expertise with us so lightly. Sharon, can I come back to you to close us out?
Yes, of course. Thank you all so much. It seems like we opened more doors than we had time to actually go into, and hopefully this will only be the first of these conversations. I see other questions in the chat that are very interesting, so maybe our speakers could take a look, and of course feel free to reach out if you didn't feel like your question was answered. And thank you again, and looking forward to future collaborations with Ella.